Okay, hello everyone. Welcome to the October Lower Providence Township Zoning Hearing Board. Please rise for the Pledge of Allegiance. Pledge allegiance to the flag. Okay, I'm going to do roll call. Gary Brown.
Here.
I'm Chris Gertis, and I'm here. Gail Hager.
Here.
Tejal Mehta.
Here.
Joe Pucci is absent. Mark Kuberski.
Here.
Travis DeCaro. Here. Our solicitor, Eric Fry.
Here.
And Keith McLennan, who's our normal solicitor, is also absent and both are excused. So with that, Gary, can you read our statement?
Yes, sir. The Zoning Hearing Board will give all interested parties an opportunity to ask questions and testify in connection with the applications being heard tonight. After a witness for the applicant completes testimony, you will be given an opportunity to ask questions of that witness. In addition, after an applicant has completed its case, you will be given an opportunity to testify, which will require you to be sworn as a witness. If you wish to participate in the hearing on an application, you should complete the entry of appearance form, which will be provided to you by the zoning officer, Mike, who is sitting at the table here. We ask your cooperation in maintaining silence during the hearing so that both the board and the court reporter can hear the testimony of the witness. We also ask that all cell phones be turned off.
Thank you, Gary. Appreciate everyone's cooperation tonight, especially with the cell phones off and keeping the noise down. So thank you for the start of the meeting. So we have a full agenda tonight. We have 4 hearings. We're going to go slightly out of order, which will be maybe a little bit self-evident as we go through that. But I'm going to ask Gary if you could read hearing number 3 for us.
Hearing number 3 is Z-24-25, Joseph C. Burns, 3016 Peacock Drive, Audubon, PA 19403. The applicant is proposing the renovation and repair of an existing home after a flood event. The applicant seeks interpretation that sections 143-191, 143-192, and 86, section 601, section A, do not apply, or in the alternative variances from sections 143, section 191, 143, section 192, and 86, section 601, together with any other relief deemed necessary or appropriate by the board. The parcel ID of the subject property is 43-00-00580-00-7 and 43-00-00583-00-4. The subject property is located at 3616 Arcola Road and is in the R2 residential zoning district.
Thank you, Gary. Since this hearing was put on the agenda, counsel for Mr. Burns has requested a 1-month continuance to allow the owner and the council to have further discussions with the township before submitting the details of their proposal. So with that, does the board have any questions about the continuance request? Is there anyone in the audience who's here to witness or have any discussion about Joseph Burns on Peacock Drive? Yes, ma'am. So just so you know, what we're doing this evening is we're going to, in a moment, make a motion to consider whether we should continue this hearing until next month to allow the individuals to have further discussion with the township about proceeding or not. Okay, so if you just give me one more moment. So does anyone on the board wish to make a motion?
I will make a motion, Chris. I motion for a 1-month continuance on this application.
Thank you, Gary. Is there a second to the motion?
I second.
Okay, thank you. All those in favor?
Aye.
Opposed? None opposed. So we will hear this at our November meeting, which I should announce when that is. Do we know when that is? It is November 26th. So for the individual in the audience, we will be here November 26th at 7 p.m. Should the Burnses continue with their variance request. Okay, so thank you for allowing us to jump out of order there.
You okay?
Good? November 26th?
Yes, Mike was right.
Okay, thank you.
That's the only time you will hear that.
It's on record.
Wow, all right. That's rough. Okay. All right, with that, we're going to move to, back to our first topic tonight, hearing number 1. And Mark, if you could read that for us.
Sure. Hearing number 1, Z-23-33, Resources for Human Development Incorporated, 4700 Wissahickon Avenue, Suite 126, Philadelphia, PA 19144. Applicant is seeking to establish supportive short-term housing as a use on the grounds of an existing substance abuse treatment facility. Under 143-156A, the applicant is appealing the determination from the zoning officer denying the proposed use at this location. Under 143-161, applicant is also seeking an interpretation of the ordinance asserting supportive short-term housing in undefined by the ordinance. In the alternative, under 143-169C, applicant asserts a substantive validity challenge to the ordinance, claiming total exclusion of supportive short-term housing, together with any other relief deemed necessary or appropriate by the board. The parcel ID of the subject property is 43-00-03289-00-7. The subject property is located at the Eagleville Hospital, 100 Eagleville Road, Eagleville, PA 19403, and is in the R1 Residential INO Institutional Overlay District. A continuance was granted until October 24th, 2024, and the applicant is requesting additional continuance due to the pending litigation concerning this matter.
Okay, thank you, Mark. Since this application was submitted for an additional continuance discussion, counsel for RHD has advised us that they are ready to present the matter to us, the zoning hearing board. So this evening, what we're going to do is we're going to talk about when we're going to have that first hearing. Obviously, it'll be a lot of testimony. We're going to get a larger space so that we can, provide enough room for people to be comfortable and ask questions, testify as appropriate. So this evening, we're not going to entertain any testimony for or against the application, but what we are going to do is we're going to pick the dates and talk about the logistics of moving forward with this hearing, and we'll be able to announce that to the public so you have enough time to plan accordingly. So with that, I'm going to turn it over to Eric to talk about those logistics.
Thank you. As the chairman just said, we're here solely to schedule the hearing. I did have a conversation with the attorneys that we're aware of at this point to compare dates and try and come up with a time period that works for all of the attorneys in this case, and I think we found some. As of now, we're looking at scheduling the first hearing on January 29th at 7 o'clock at Arcola. And also to schedule the second hearing, which will be January 30th at 7 o'clock at Arcola as well. So what we're trying to do is get a room that's big enough for everybody. We expect a bigger crowd than this. We know that the public was aware that this is just the scheduling hearing and not the actual hearing. But I am going to ask all the attorneys, again, that we're aware of, to, on the record, say that they're okay with those dates and times for starting. I guess I'll start with the applicant's attorney, Mr. Jonas, if you want to introduce your team there for the record, and then I'll ask you some questions regarding those dates.
Good evening, I'm Mark Jonas, the co-counsel introduce themselves.
Good evening, Mike Peters. Good evening, John McShea.
So, are you and the applicant, are you okay with starting the first hearing in this matter on January 29th?
We are.
And you will, I guess, renew your extensions as they apply to both the MPC and the township's ordinance for the scheduling of the first hearing?
Yes, we will.
Okay. I'll ask the same questions of Mr. Clark. You're here for the township, correct? I am. And the January 29th and 30th are okay with your schedule?
We are good with both of those dates.
Okay. And are you okay with starting having the continuance last that long?
Yes, we are.
Okay. And then I have Mr. Yanoff.
Yes, sir.
You provided me, again, just for the record, did you provide the list to anybody else?
Not yet.
Okay, which I'll make sure I do after tonight. Mr. Yanoff handed me a two-page list, which I will make, and when we actually start the hearing, I'll make this part of the record. List of individuals. The reason I'm not giving you the count is because some are, I'm going to assume husband and wife or spouses, and some are individuals on this list. So, but it's a list, two-page list of parties, and you represent these parties?
I do.
Okay, are you also okay with starting the hearings on the 29th and 30th of January?
I am.
Okay, thank you. And Mr. Bagley? If you introduce yourself for the record, please.
Joseph Bagley.
Thank you.
I represent Streamlight Inc.
And you were also involved in the conversations to have the hearings start on January 29th and 30th, correct?
I was.
And you're okay with those dates?
I am.
All right, thank you. Are there any other parties that have representation? Any other attorneys? And just so you know, you're not precluded, once we start the hearings, to participate in them. The first hearing, what we will start with on January 29th, we will start with asking any individuals whether they want to become parties to this matter, and you'll have a right to stand up at that point, introduce yourself, give us your address, at which time Mr. Jonas and the other attorneys could question you, whether you have standing or not. They could object to it or agree to it. But that'll be really the first step in this matter, other than some procedural things, just to enter some exhibits on the record. And there'll be numerous exhibits given the length of continuances, things like that. But the real first procedural thing for the public to know is that we will find out who want to be members of the public. What then happens is the applicant will present their case through sworn testimony and exhibits. Any parties can ask questions of those witnesses and things like that. We will then go to the attorneys to present their cases for or against this application. And then after that, we will open it up to any other individual parties to do the same thing, which if you're a party, you'll have the opportunity to present evidence for or against this application as it moves forward and to make argument at the end, again, whether you are for or against this application. But all that will happen starting January 29th at 7 o'clock at Arcola. Do any of the attorneys have any questions or of any of the other parties or want anything on the record for this evening?
I do not.
I see one member, Ms. Esky.
Could you come up to
Just
the
come up.
microphone? Thank you.
And I do, and just while she's walking, I do want to limit questions because again, everything will be answered on the 29th, but
I have two questions.
sure.
So is the board automatically going to give them an extension to January?
Yes.
Yes?
It's scheduled for January,
Okay, with no discussion.
correct.
And has RHD modified their application in any manner?
Not that we're aware of.
Not that we're aware of.
And if they do, will we notice that before the January?
I don't know the answer to that question. If they do it the 28th, probably not. If they do it ahead of, before us, so what we plan to do is re-advertise this, just like it's a first hearing. So it'll be re-advertised, so even if you're not here, it'll be in the paper, the property will be posted, and the list of property owners who are set forth in the ordinance, and I don't know what it is, but whatever the radius of that, they will receive letters on this application too to know to show up on the 29th.
And anyone that had, I'm sorry, I got more than two questions, had signed up for standing, will they receive?
You'll have to,
as well?
I guess you can work it out with the township if you want a mailer.
We will receive that, anyone that has, okay.
And just as the record, Mr. Merzinski shook his head yes.
Oh,
Yeah, I want to hear it again as well.
okay, I don't think I have any more questions
All right.
at the moment.
Thank you.
However, at the end of this, not to keep everyone, I do have some information that I want to share about you, with you all, about standing and who is eligible and what you're allowed to do.
We'll probably, if you're saying the end of, you're saying the end of tonight or the start of the?
Right, after all the other applicants are finished, just as a follow-up.
Understood, but that'll be determined at the first hearing. So you have a right to come up and try and become a party, try and have standing. But again, that's subject to voir dire, having Mr. Jonas or any of the other attorneys or any other party ask you questions whether you have, and then the board will decide whether you have standing or not to be a party at that point.
Right, I do understand that, however, there is a clause where well, I might as well just go through it at this point.
No, we're not gonna take it right now. Nope.
Okay, but it has nothing to do with that.
I understand.
It's additional information for the board that I would like to present and after all the applicants
I-
have had their opportunity.
But that's for this case. We're gonna end,
It's not for this case. It's
just in general.
information for the board.
understood.
Okay?
We'll address that at the end of the night then.
Exactly.
So, and just so it's clear, you came up and said whether we're going to grant this continuance to January 29th. The applicant's telling us they're ready to move forward with their case, so they're not asking for a continuance. So really what that starts our clock that we have to have a hearing within 60 days. By comparing us trying to work through the calendars to get a date that actually worked, those were really the first dates that worked. So, and they were gracious enough, because I think that's more than 60 days from now. So maybe it is appropriate that we would grant the continuance to the 29th and actually take formal action. And I understand and I appreciate that. But again, the applicant didn't request it. They're requesting to move forward. But in the cooperation with everybody, they're also allowing us to go beyond that 60 days because a date didn't work because of the holidays. We have Thanksgiving coming up, which wrecks November, the end of the year holidays as well wreck it for December. So so there's other reasons why it's getting pushed out to them, and it wasn't all the applicant. It was a combination of all the parties. All right, I appreciate your time. Thank you. So board, why don't we formally vote to continue this thing for the first hearing to start January 29th at 7 o'clock at Arcola.
Okay, someone want to make a motion to that?
I'll make a motion that we have the first hearing on January 29th.
Thank you, Gary. Second?
I can second it.
All those in favor? Aye. Opposed? None? Okay, so thank you for that input, Ms. Eske and Eric. So is there anything else on RHD? Okay, if not, you are more than welcome to stay and see how we conduct business for hearings. If not, I'm going to ask you to just leave the room, and we'll pause for a couple seconds here. Okay, thank you all for staying. Oh, we ready? Okay, thank you all for staying, and we're going to proceed now with hearing number 2 on the agenda. And Tejal, if you could read that for us.
Sure. Z-24-24, Roger Eastman, 76 Smith Road, Collegeville, PA, 19426. The applicant is proposing the replacement of an existing 216 square foot shed with a 336 square foot shed. The applicant seeks relief from section 143-6.2.b, paragraph 2, and dimensional variances from section 143-33 to permit rear yard setback of 12 feet where a minimum of 60 feet is required, and a side yard setback of 12 feet where a minimum of 50 feet is required, together with any other relief deemed necessary or appropriate by the board. The parcel ID of the subject property is 43-00-13648-00-7. The subject property is located at 76 Smith Road and is in the R1 Residential Zoning District.
Thank you, Tejal. Is someone here to represent the case?
I am. I'm Roger Eastman.
Okay, can we swear you in, Mr. Eastman?
Roger H. Eastman.
Okay, thank you, Mr. Eastman. If you could tell us about your project.
Could I interrupt? I don't, if I could just I don't know how you normally do it, but I want to put some records,
Exhibits in?
some exhibits
Okay,
in if
we
I
don't
could.
normally do that at the end, but go ahead. That's fine.
Yeah, thanks. So B1, we're going to mark as your application package. B2 will be the legal notice. B3 will be the proof of publication. B4 will be the certificate of posting dated October 7th, 2024. And then B5 will be the certificate of notification, which includes the letter to the residents as well as the list of property owners. And just for the public's purpose, and I know they probably talked about it some more, is essentially, is there anybody here for or against this application? All right, are you together?
Sort of, he's my neighbor.
Okay, so just so you know, the way we handle this is we'll take all of your testimony, just like I said for the prior application, we'll take your testimony, your evidence. We will then allow members of the public to question you, then to present evidence at the end as well, and then present any opinions that they have. Do you want to become a party to this case, or you do? Come on up. You could just state your name for the record there.
John Heiser,
You spell your last name,
Heyser, and that's John E. Cavalier,
and what's your address, Mr. Heiser?
Heyser, 80 Smith Road.
Great, thank you. And then we'll let you take over, Mr. Eastman.
Do we need to swear Mr. Heiser in?
Not yet, we'll
Okay,
wait.
all right, very good. Okay, so, thank you. So, Mr. Eastman, if you could now describe your project to us.
Okay, I have a somewhat lengthy presentation.
Okay?
Given the
Bless you.
interest in time, I have a Cliff Notes version of this, if you would.
Well, thank you very much. We appreciate that.
You want
Cliff Notes is, yeah, and if we have questions, we'll
Okay, I hope I can
dive deeper.
answer all of the questions. The basic project is I have a 12 by 18-foot shed. Now store my tractor and lawn implements, and various other things in. Tree fell on it about 6 or 8 weeks ago, so it's damaged, which got me to thinking about replacing it. The idea of replacing it seems a good idea, and it also enables me to store more stuff into it. So that's the basics of the why, the what happened and why. And I submitted the application for that. It became clear that if I wanted to go over 250 square feet, I had to come move where the shed is. The shed's currently sitting on a 25-foot by 25-foot concrete pad. So moving the shed anywhere else on the property is, it's not terribly practical. One, I'm not moving the pad, and two, to leave. Mike, did you enter in the updated pictures that I sent you? If not, no. Okay. That did. As you can see on the diagram, where the shed is 12 feet from the two borders. The property is not rectangular, it's an unusual shape. You can see on the diagram, so there's no clear front yard, backyard, side yard. So the 50 or 60 foot setback in either case puts the shed would be inappropriately close to the house. It would be within 10 feet of the house itself in some cases. So that seems to be part of the primary hardship. The other places considered in the front yard is, I understand the zoning requirements is pretty much a no-go. I don't think anybody really wants to have the yard. practical purposes, I consider pretty much anything in front of the house down here to the street as a front yard. Not gonna do that. The area over here, driveway comes up here and it slopes off rather dramatically. Don't know the exact angle there, but I do not want to drive, I will not drive my mower across that, always up and down. So it's pretty steep and it's sloped down here. The area over here, I have a geothermal system placed in about this area. And there's an area up here, I believe there is an underground or a surface spring up here. This is wet. It almost makes a nice ice skating rink for me in the wintertime. And the area over here, there is a intermittent tributary, a storm stream that comes across the property down here. So, and it being wooded and the stream comes in this area really isn't very practical for putting a shed. The only real practical place, given the topography and the layout of the property, really is back there.
So I'm just going to help you out a second. You're fine. So as you're walking, I just went for the record. She doesn't know how to take the word here, so I'm going to do it for you. Okay. So what Mr. Eastman stated was property to the right of the home facing from the roadway.
Mr. Eastman.
Hang on a second.
Mr.
Just
Eastman, if you could just listen to Mr.
so it slopes heavily from the home to the property line there, to the rear left, again, facing the home from the street. The rear left of the property is a geothermal area. Immediately to the area to the left of the proposed shed is a spring, and to the far left of the property is an intermittent tributary, and then really the area to the back and left of the home is a wooded area that you were trying to preserve. So I just kind of put that in perspective, so she got it all down for you, okay?
I have some additional pictures that you can get in.
Okay.
Help.
Sure. And I didn't want to interrupt your flow of things, but I wanted to make sure I got that on the record for you.
I was hoping that adding that would make the record.
Yeah, so just wait for him to get him loaded up, okay?
Okay. The shed that I want to replace this with is 14 feet by 24 feet. The size was picked 24 feet because I got 25 feet on the pad, and 14 feet is 2 feet wider. It will be located on the pad, completely on the pad, and will replace the existing shed. Another issue, to full disclosure here, the shed has power running to it. I have a welder out there, and the ability to run a compressor. There, that was put in, permitted, that will be reinstalled. I assume I'll have to get a new permit to put that back in. So that's also what I would consider a hardship, to have to move all that. If I put the shed anywhere else, all of that conduit has to be redone and gone somewhere else. Given where the property and the driveway is, probably I would have to go through the driveway, probably the second most reasonable place to put this. I'm trying to address the, what do you call it, the top five. The physical circumstances, the irregular lot shape. There are a few, the strict interpretation of the zoning ordinance would force the shed to be somewhere that is inappropriate based on existing underground, geothermal, high slope on the other side of the driveway, and the surface springs near the stream or in the front yard. So that's what I would consider the zoning ordinance strict interpretation exception. This is not a created hardship, and to put that back there, the concrete pad is is there, and that was put in with the shed and all the good permits for that. The essential character of the neighborhood. There are 7 houses along Smith Road in that area. Every single house along there has an external building of some sort. And there is a picture, in 1 minute. I have a picture in there that shows, it's a Google map picture, which shows all the properties, and all the properties, you can see it's heavily wooded on both sides of Smith Road, as well as various properties, all the neighbors all have external, a shed or a garage of some sort. So there's a pretty decent setback. Most of the houses are back at least 70 feet from the road. So the essential character of the neighborhood, I just don't see how it would be impacted. As in the application, the minimum setback, 50 or 60, depending on how you define it. Pad is now 12 feet in. As you can see from the diagram, from the 2 closest boundaries. That's the Cliff Notes version.
That's good. So,
Any questions?
Yep, thank you. Any questions from the board? Mr. Eastman? I have a couple. The placement or the location of the concrete pad, was there a variance associated with that in the older shed?
No, there is not.
Okay,
so if I could clarify, I think the reason that the setbacks apply is because you're going over 250, or the size of the shed is increasing, so a smaller shed can be closer to a property line,
I
so.
believe, I can probably correct me, it's 5 feet for a shed.
correct,
So when I put it in, I didn't want to be that close, so I
right.
pulled it back.
Okay, thank you.
I ended up wanting to do all the things I might want to do.
Appreciate the clarification. And then you said there's going to be power, but you don't have any other utilities, no water or sewer or anything like that? Okay,
For full disclosure, I have power, fresh air going out there, and low voltage signaling.
okay,
And I have a Wi-Fi.
okay, very good.
But that's all buried in conduit.
Okay, perfect. Okay, any questions besides mine for the board?
So this is going to be a prefabricated
Yes.
model?
Yes. The question I do have is the height restriction. Looking at the terminology, I wasn't sure whether this would be considered a shed or a garage. I was determined that it be considered a garage. The use cases, description of them is nearly identical. And as a garage, it has included as an or, what's that, 143.62K, definition of household garage. The accessory building says for the storage of personal items, which reads very similarly to what it says. And if I do that, there's a height restriction on the shed, 12 feet, and there is not one for the garage. And the reason I bring that up is I went out to visit some places, look for, get an idea of what I was getting into, and nobody seemed to specify how tall it is. Peak. A little bit more research here. The height of the building, I understand this, is the mean height between the eaves and the ridge for gable hip and gable roofs. So that tells me it's kind of halfway up to the measurement point. Is that interpretation?
That would be correct.
My anticipation is, what I've seen is, peak probably will be up around 14 feet. Peak.
You would fall under the
Yeah,
maximum height by the definition of a height of the building.
So So why don't we mark and you have the capability of saving these pictures? Okay, why don't we mark your group of pictures as applicants 1, A1?
I think you can see two, let me see which way. Up there, up towards your place. So the fourth is up here. This is the north and west. The north and east property.
It doesn't matter, just,
Towards Smith River.
There you go.
The whole purpose of this is a wooded area. It's heavily wooded. So visibility to the neighbors, closest neighbor is over here, from around here. And it's only in the winter that you even see that it's there. And again, pointing out the outbuildings on every one of the properties that surround.
you just had the one photo?
Well, I
here's-
have a whole bunch, but that gets out of the clip notes version.
Gotcha. There's a picture of, is that your proposed shed on the screen right now?
No, yes.
Okay.
Yes. That is a, they have the 3D design program, that is representative.
Okay.
My wife has final say on the color.
Smart man.
The way it should be.
She agreed that the brown with the chestnut seems to be okay.
Great.
There should be one in there that says, Smith Road 76 Smith Road property definitions. That picture I filled in to show the areas where the geothermal is located, where the stream is located, where the sloped areas are. If that helps.
Does, thank you.
Thank you. Okay. So, board has no additional questions. Mr. Heiser, would you like to introduce do you have any questions or testimony you'd like to provide? Questions?
And Mr. Heiser, if I could just, are you gonna ask questions or are you gonna make a statement? You're gonna make a statement? So why don't we get sworn in first, okay? You're gonna get sworn
I'll
in?
swear you in.
State your name for the record. Swear firm. And this matter, the truth, the whole truth.
Thank you, Mr. Heiser. And if you could,
The aerial. There you go.
Property on the right-hand side is mine. And the empty lot there has no house. It's also mine. And I have 40 acres there. Of that 40 acres, 2/3 of it is woods. Where he lives and I live, a third of that is that street. I've been down there, he's been there for a long time, he's fine. As long as he doesn't run his mill or his air compressor on Sundays, my wife can lock him up. But other than that, there's plenty of room there. And, I don't expect to do anything with 40 acres.
thank you, Mr. Heiser. Is there anyone else in the audience who would like to ask any questions or testify? Okay.
Can I just ask one, because Mr. Eastman, so Mr. Heiser, does he own the property that abuts both the closest points to where the shed's going? Yes. Both property line? Perfect. So you basically wrap around the three sides that are closest to where the shed's going. And Mr. Heiser, you have no objection to what is being proposed by the applicant? Thank you. I guess, could I phrase it a different way? Do you support what the applicant is requesting? Even better, so thank you.
Thank you. Okay, Eric, do you have any additional housekeeping items?
Not, thank you.
Okay, with that, we're going to pause for a moment, and we're going to go in the back room and deliberate. Okay, we're back, and we are going to reconvene the meeting at this time. And Tejal, I believe you have a motion to present?
Yes, the motion to approve variance for section 143-33 to permit 14 by 24 feet garage, which is 12 foot from the side and rear of the property line, subject to the following conditions. One, the maximum height shall be 16 feet to the ridge peak. Two, no other utilities other than electric and internet can be installed. And three, all the development shall be consistent with testimony and exhibits presented.
Thank you, Tejal. Is there a second?
I'll second that.
All those in favor?
Aye.
Opposed? None? Congratulations, motion carries. Good luck. Thank you, Mr. Eastman. Okay, we are on our last hearing of the evening, and Gail, if you could read that for us.
Sure. Hearing number 4, Z-24-26, Jacob Echevarria, 305 Hillside Avenue, Norristown, Pennsylvania, 19403. The applicant is seeking a use variance from section 143-36 to allow for the continuance of multiple dwelling units on the property, together with any other relief deemed necessary or appropriate by the board, together with any other whatever. The parcel ID of the subject property is 43-00-06295-00-7. The subject property is located at 305 Hillside Avenue and is in the R2 residential zoning district.
Thank you, Gail. I do have one announcement before we get started. Gary Brown is recusing himself from this hearing. He will continue to stay up here and can ask questions, but Travis DeCaro will be a voting member. So, Mr. Echevarria, are you, okay? Okay, thank you. How do you say your last name? Echevarria. Do you have a counsel representing you?
I do not.
Okay, very good. If we could swear you in then?
Absolutely.
Okay, thank you. And Eric, would you like to do exhibits?
Thank you. B1 will be the application package. B2 will be the legal notice. B3 will be the proof of publication. B4 is the certificate of posting dated October 7th. And then B5 is the certificate of notification, which includes the draft letter and the list of property owners. And as we did with the last case, are there any members of the public who are here for this application? There's a lot of hands. So I'll explain party status for you. You don't need to be a party to participate this evening. This board will allow you to ask questions and then to present evidence and or a position at the end. However, if you wanted to have appellate rights, which means the right to take this decision and appeal, good or bad, and appeal it to the Court of Common Pleas, you'd have to become a party. No cost to become a party this evening. However, there would be a cost if you wanted to appeal, and that would be the cost of a litigation matter. Is there anybody who wants to be a party to this application? I don't think I see any. Okay, if there, okay, thank you. So we can move on. Okay.
Okay. Okay, if you could tell us about your project.
Sure. We purchased the property last October 2023. When we purchased the property, we purchased a single-family home with 950 square feet in the main house, and then it had a detached garage. From our ideas, the detached garage was fully functional. It had a living room, dining room, kitchen, bathroom. We thought the whole time that it was a living quarters in the detached garage. Once we had the detached garage, we found out that there was some engineering that needed to be pulled, so we had some engineers, architects, making sure that the flooring structure and everything was proper. As we go later on, find out it's actually not listed as a dwelling. So that's why we're in this process. Obviously, engineering, we did all the improvements to it. We never changed anything whatsoever. It always had a fully functional kitchen, it always had a fully functional bathroom. It was just running there. What was also surprising to us, it has its own pico meter, and the pico meter has its own address status to it. So it actually has it at 305 Rear Building. So the whole time we're thinking that there was two kind of living quarters. It's not listed as two living quarters. The property was built back in 1938, so which is before permits were required, and some of our records don't go back. We're not really changing anything within the structure of the building or
Okay. Any other testimony you'd like to provide?
No, I mean, it's self-evident. It does have two driveways. Again, all that was there when we got there. So we haven't really changed much. Everything we've done is really cosmetic. When we got there, it was the house was the eyesore. We heard and fix the property. Ideally,
Okay. Board questions?
Didn't we say that if it was an in-law suites allowed? Did we say that?
I have to look at the code, yeah. Or Mike, do you know?
Yes, it did. An in-law suite in that zoning district, subject to the conditions of the property owner issuing an affidavit asserting that they were certain conditions.
So is it permitted by right or special exception or
It's by right.
subject to satisfying the other criteria of the code? Okay.
obviously, we want more than just the in-law suite. I'm not gonna live in the property, per se.
So your intent is not to treat it as an in-law suite? You're going to rent
No,
it?
I said it has the capability of being an in-law suite. My intent, honestly, my business partner's mother is supposed to move to the main house, and his cousin's supposed to move to the garage, but they're gonna pay rent. My understanding is you can't let them live there and pay rent and still consider it. At least that's what I was.
There is a relationship requirement, meaning a familial relationship. I don't know if cousin works. I don't know how closely they have to be related, but I don't know there's any prohibition on paying rent or anything like that. I don't even know how the township would know that. It's not him. Yep. But it's so, and that's not that, so an in-law suite wouldn't link necessarily to the owner. Maybe it does. Again, I don't know the code here, but it would be whoever's living in the main house, the other person would have to be related as close as enough as possible to satisfy what's in the code. And I only picked up my copy of the code tonight since I'm special counsel, so that's why I'm not as familiar with this code as I should be, so I apologize. So I don't just, is cousin close enough? Or I honestly don't know sitting here. Yeah, it's probably borderline. And don't answer if you don't know. I don't know is acceptable. I don't know here sitting here either. So. Yeah. Yeah. Yes.
Mother or the cousin were to leave, then that,
So can you clarify what the relationship between your business partner's mother and his cousin would be? Are they relatives?
That's it.
That would be her nephew.
My business partner is my wife's.
For the record, the person occupying the primary structure and the person that you would be proposing to occupy the accessory structure would be by his nephew and aunt.
Again, I was going down that road with them, and purposely here is, that's for now. The mother is older or whatever, but we were specifically, it should have always been this way. So you see what we're.
So what you're asking for essentially that to not require that familial relationship and allow both places to be rented independently of the other.
I don't want to have to do this again. For years,
Okay, any other board questions at this time? Okay, there were many folks in the audience who'd like to ask questions at this point. Like to open it up to, yep. So if we could, anyone who wants to come and ask questions of Mr. Echeverria, please step up to the microphone and state your name and where you live. Yep. You stood up.
Good evening, ladies and gentlemen.
Can you state your name and where you live, please?
My name is Pat McKernan, McKernan. I reside streets away from the location of 2912 7th Street. First, if it's okay with.
So just you know, this is for questions now. So if you're going to present something, just hang on to that. So just questions from Mr. Echeverria right now. We'll give you a chance to make statements in a second. If you have it, let's just stay there for a second. Stay there. Does anybody else have questions for Mr. Echeverria? So stay there. If there aren't, you have questions? Okay. I was going to stay there. If there weren't any questions, we're going to let you go ahead and make your statement. So.
Okay, you ask your question.
That is above.
I'll be honest with you, not, we typically don't purchase houses to rent. Notice, my company did. See the sign. we don't normally do that. We don't normally fix it. This is more.
So
In perpetuity.
your original intention when you bought the property was specifically for your
No,
business?
well, it wasn't specifically to put her in there, no. When we purchased it, it was specifically to keep us in business. So the only time we get slow, basically, we start a project, we say, oh, we can do this project.
But then were your intentions to sell it?
No, no, not a
So it was never to sell it. So at some point you were gonna put someone in there, whether it be a tenant or your business partner's mom, and now nephew.
Well, I think we, I don't know if we always had the intention to sell it. We always had the intentions of, fix it up, see what we can do. She needs a place. But we don't have no long term. Long term, we probably are not gonna put people. Okay, that's okay.
Thank you. Any other questions before we ask for testimony? Okay, your turn to testify. And before you do that, we're going to ask Paula to swear you in. So if you could step up to the microphone.
My name is Patrick McKerney. Before I start, we have aerial photographs of the location in question. So I'd like to know if I can present to the board, if it's possible, scan pictures of the actual property. Everyone's familiar with it?
Why don't you show him first?
So it actually depicts the property in question.
Any objections to those? That's right. So,
They were recent, good.
so, so we will, so why don't you hand them to the chairman here?
And we'll pass them around.
So there's four photos?
I think this total.
There's four. So we're gonna mark the 4 photos as McKiernan 1.
I don't know which ones I'm gonna talk to, but.
All right.
we'll start with-
They're all on the record.
Number one, I'd just like to give my personal opinion of what the exact word in-law suite means. I've been married, and I know what in-law means, mother-in-law or your father-in-law, okay? So a relative, in my opinion, R2, is not covered under in-law suite. Relative or anything like that. The second thing is, the gentleman just spoke and said his intention is to resell. Number 2. Number 3, if the mother of one of the owners moves in, and number 2, one of his cousins moves in, one of them moves out, then what happens? Looking down the road here. So with that being said, I have a few things of my concern. Number one, I am opposing the apartment at that particular location. According to your zoning, it does say it's for in-law suites, anything other than that. It wasn't until it was brought to the zoning officer's attention that someone was living at this particular location for a period of time. Automatically moved in. The other thing is, my concern is, if the house is going to be an apartment, that's one. House on the second floor garage, that's 2.
Thank you.
There may be questions, though. Mr. Echeverry, do you have any
I
questions?
just wanna say, it's,
Questions for him right now. We'll give you a chance to rebut whatever he said.
no, I wanna make sure he understands, it's not. And I didn't build.
According to the zoning, this is multiple dwelling.
Understood.
Okay, so-
He's asking for a house and one apartment. I understand what you're saying, just,
Sign is not indicated.
I understand what you're saying. But I do have questions for Mr. McKiernan. How long have you lived there?
1994, 30 years.
Do you know how this property was used previously? Was
Family home.
but was it an in-law suite or an apartment?
in-law suite.
It was an in-law suite before. Okay, thank you.
Okay, thank you.
Thank you very much.
Additional, if you have a question, other, okay,
No, no,
we'll,
no, no,
okay,
no,
hold
no,
on,
no.
we'll ask you to,
They get to go first, then you get to come back on, okay? Yep.
any additional testimony from others in the audience? Okay, we're gonna need to swear you in.
And I have resided at 400 Hillside Avenue since 2006. The house that was there prior to was a family home that my son lived to take care of the mom, the elderly mom, above the apartment. There was also an uncle that lived on the property in a trailer home that we put up with for many years that threw pea buckets out the front door. So we are kind of a little uncomfortable with the fact of having tenants move into the neighborhood. We've had issues with other tenants down the bottom of the hill running after cars where we've had to meet with Chief Jackson. This is a single-family community. And now, as Pat said, there are a lot of kids in our neighborhood. We've never handed out a piece of candy until recently. Having random individuals move in, I'm sorry that you bought the house and that you didn't know that it wasn't split. However, it's not split. It's meant to be a single-family home. And if you needed a child or someone to move in to take care of an elderly mom, like what the Rubendals actually had, then we could understand that. But just splitting it to have random people move in, he only bought it as a project because they weren't busy. But this is where all of us live, this is where everyone's kids are. Out to random people after someone passes or has to go into a home or moves away.
Thank you. Any questions? Questions, okay. Thank you for your testimony. Additional folks who would like to testify? Come up, sir. You can state your name for the court reporter.
Michael Atride, A-R-Y-D-E.
I'm sorry, where do you live?
I live at 2975 4th Street, which is adjacent to the property.
Thank you.
So, ma'am, since he's sworn in, and I appreciate you pointing that out to us, but he's the only one that can talk right now, okay? No, it's okay. We just have the court reporter, so I have to make sure that she's got the ability to type everything down.
So my fiance Maria and I, as we said, live at 297 4th Street, and we're also opposed to the applicant seeks consideration of the findings that the applicant must establish in order to carry the burden of proving that the zoning ordinance imposes unnecessary hardship requires, in our view, the conclusion that the variance should be denied and that the applicant is not carrying this burden. First of all, there's no unique physical circumstances or conditions on the property that the applicant has in-law suite or attached garage, however you like to characterize it. It doesn't constitute a unique physical circumstance or condition on the property. Furthermore, it clearly cannot be said that any alleged physical circumstances or conditions on the property create an impossibility to develop the property and reasonably use it in strict conformity with the zoning ordinance, because it's perfectly reasonable for the property to be used as a single-family detached dwelling, just as the rest of the law-abiding citizens in that zone currently use their property. Furthermore, as my neighbors have pointed out, the only unnecessary hardship that the applicant alleges has been created by the applicant having purchased the property without understanding of the zoning. The variance would alter the essential character of the neighborhood, as the applicant presents the slot variance as the continuation of a multi-dwelling unit use. However, as my neighbors have pointed out, the previous owners of the property or residents of the property were members of a single family, and I understand that the applicant intends to have it temporarily used as arguably a single family use, but that's not what's being requested. Being requested would be for variance. Lastly, because of that, and as considering that, the fact that it was previously used by members of a single family, and the fact that everybody else in that neighborhood uses their property as single-family dwellings, at least the law-abiding citizens do, residents do, variance would alter the essential character of the neighborhood. Lastly, the variance would be contrary to the public interest and detriment to public welfare. My neighbors have raised a few great points about why the public interest and public welfare would be impacted by the variance. For example, the increasing allowing the applicants to rent the properties in multiple families would increase traffic and overcrowd the land in an already congested area, adversely affecting the appropriate use of adjacent properties. The variance would not be consistent with the spirit and purpose of the zoning ordinance, which such spirit and purpose includes the protection of the reasonable expectations of those who purchase and live in homes in the R2 district, that multiple dwelling use will remain prohibited in their neighborhood absent extraordinary circumstance. The variance would lower nearby property values to the benefit of a landlord who does not live in the community, but at the expense and detriment to those who do live in the area, who do live in our town, and positively contribute. Ultimately, the applicant seeks the variance in order to increase their profits as a landlord who does not live in the neighborhood. The applicant's inability to do so without the variance falls well short of constituting necessary hardship.
Thank you. Any questions for the,
I don't live in the area.
You live in the neighborhood?
No, do we know each other?
I think didn't you say that you are going to live in the property? Right, that's what I mean.
You were saying I didn't live in the area.
Okay, but you don't live in that property. You don't live in that street. You don't live in that neighborhood, and you're going to rent out the property, right?
thank you. Appreciate it. Additional testimony? Yes, ma'am. Yep. If you could, when you get to the mic, state your name and your address, and Paula will swear you in. You could pull the microphone down a little bit so we can hear you. Thank you.
We have our family, there's two families together in the house, and we were expanding our house. And it was made clear to us at the time that we were not allowed to rent out to anyone but our family. And we had to sign papers at the time that we were not allowed to do that because it was owned residential. So I don't think it would be fair for anyone else in the area, to be able to rent out to anyone but family.
Good. Thank you. Any questions for? Thank you very much. Additional testimony. In addition to what you already said?
Yes.
Okay, come on up.
I can't see you.
That's okay.
I just like.
Oh, no.
Come to the mic. You're already sworn in, so if you can just continue.
I'd just like to re-clarify one of the statements I made earlier. In relation to the photographs that you see that were presented before you, I indicated there'd be 1, 2, and possibly 4. If the lot was also built. If you look at the photograph, there's a set of double doors on the lower level, which is equal to square footage of the upper level. My understanding is that lower level is only level. That that's a potential for 5%.
Question?
I can answer.
We'll give you an opportunity, but just keep track of that. Any questions for, okay.
But I can answer.
Okay, well, we'll give you a second. Give me a second.
Thank you.
Thank you. Additional testimony? Yes, ma'am. You know the drill, name, address, and we'll swear you in.
Slightly down the road, and I live at the dead end. I drive up Hillside by.
Okay, we're gonna swear you in first.
Oh, sorry. My bad. So I drive up Hillside to Fifth Street with my husband to come home. We were, like I said, at the dead end of Fifth Street, and this is on the right side as we drive up. Currently, how the house stands, I am for what it is, but I am against splitting it into two dwellings. Like previous people have said, I am for single-family homes in the neighborhood. If you look at the neighborhood now, it is mainly single-family homes, except for at the bottom of Hillside. As previously people have said, it is a little bit of an eyesore at the bottom of Hillside, and I do not want transient people coming and going within the neighborhood. It is a roll of the dice on who you have within a home or a rental property. I have lived in rental properties now in the area prior to moving into this home for several years within Montgomery County. And you, like I said, have a roll of the dice of who is your neighbor. You can have a great person or you can have a terrible person. And transient people within the neighborhood, I'm just not for. I really would like this to be a single family or multiple family if it was, like they said, in-law suite. Thank you. An in-law suite, I would be for that, but I'm just opposed to having multiple people living in the area, and it can bring down property value. And as Pat previously stated, there is that vacant property next to it, and I have to worry that more dwellings, such as apartments, can be put onto that property. And I do not want apartment buildings driving down the property value of not only my home, but other people that live within the neighborhood.
Okay, any questions? All right, thank you. Additional testimony? Yes, ma'am.
Three of the girls
Okay, thank you. Any questions? Okay, any additional testimony? Okay, Mr. Echeverria, your turn if you would like to provide any additional testimony.
I mean, if we took the property, same goals in mind as we were trying to make the beautiful, really change. That house personally was a house. So I know doing the work that we've done to that location, it has raised the property value for everyone that's, currently up here. So it's lowering and the house, the garage, to answer the gentleman's question, that it's already drywalled. So township actually has drywall because it's a garage, has 11 quarters above it, and it needs to be fire-coated drywall into that thing. So we actually, it wasn't there before. Property values going up. Renters are not evil. I know we come and we put that the renters are evil. We have to remember that the house is about 900 square foot. You can't fit more than 3 people. The garage apartment that's above, it's less than 400 square feet. 350. Not more than one person can fit into the apartment. We're not looking, we own 20,000 square feet. So not only do we own the property right next to it, which is not the corner, we also own the property to the right. So we're not talking about we're taking all this, putting thousands of people. You're talking about less than what current houses have, with a much bigger footprint. So again, we're here to do the same thing. We want the neighborhood to look beautiful. We want the properties to go up for everybody. We want the neighborhood to be safe. Obviously, we're not going to put, business partners in a unsafe neighborhood. We want them to be safe. I just know what's happening. We're in the same boat as everybody else. We want it safe. We want the neighborhood to be beautiful. That's all else we can say.
Okay, thank you. Board, any final questions?
And the final thing I will say, the property was built prior to 1940, so we do not really know whether that was already allowed or not. It's an R2 now, since it was built prior to 1940, technically should have been grandfathered.
Okay, thank you. Eric, do you have anything?
No.
Yep. Question, testimony's done?
No, Mr. McKiernan.
Come on up. Well, we're gonna let Mr. Echeverria address any additional testimony you have.
Pat McKernan again. I do have a couple questions, I'm sorry. Question to you. Downstairs unit, is that equal square footage of the upstairs unit?
I believe so.
Number 2, is there a water and sewer going back to the upstairs unit already?
So, interesting you say that, yes, there's already a sewer.
So that sewer line could be tapped into if the downstairs unit, it can be built into another apartment, is that correct? You have access to water, sewer, and square footage for another unit downstairs? No?
No, you can't. First of all, you would need an ordinance to do multiple.
I'm not saying that, I'm asking you a question. The downstairs unit, square footage equal to the upstairs unit, if you have water and sewer, back to that particular property.
I don't know what the, there's zero bank from that.
Mr. McKern, I might be able to help you out here. So while the use that's in the code is called multi-unit, this application right now is only for 2. No. He's only asking for 2. So if this board would approve anything, they would make sure that it's limited to 2. If he would want to expand beyond 2, well, let's go with the assumption he gets 2 tonight. If he wants to expand beyond 2, he'd have to come back here to ask to expand to 3. So I understand your questions, but that's for another hearing. If he would win this case, you'd have to come back and make those arguments at that time. But today, while it can happen and can physically fit, as your questions are leading to, he's not asking for that. This board is not considering that. We're only considering basically a single-family home with an in-law suite, or 2 apartments, essentially.
I have one more question. Some of your statement to the ladies and gentlemen of the board, you indicated, in one word, you don't know what's gonna happen.
No one does.
Understand it. This is our future, right here, sitting before you, Ken. Okay, this is our future. He doesn't know what's gonna happen in the future. We gotta live there when the property gets sold. That's what I'm trying to say. Thank you.
So if it leads to one more question for me, Mr. Echeverria, how many sewer bills do you pay for here? 1 or 2? Just 1.
Okay.
The only thing, to my knowledge, is the meter is separated.
Caught that.
Right, got that.
Everything else is
Single.
one,
Okay.
one bill.
Thank you.
Okay, thank you. Did you have something else? Can you get in front of the microphone? Or you could pick the microphone up and walk over there if you'd like.
I own all these here.
And do you have any intention for the rest of those?
Again, this is not our.
Okay, and I understand what you're saying, and you did do a very nice job in fixing up the house. I believe. However, a point if the main house is 900 and some square feet, and you're saying you can fit 3 people, my house is 1,142 square feet, and it has 7 people in it. When the Rubentals lived there, Mr. Rubenthal lived in the main house, and 2 people lived in that tiny apartment above the garage. We all know that way more than what you're saying can live there.
Well, sure, sure, you got kids, you can live in those small little rooms, yeah.
I mean, it's definitely doable, and we don't know what you're gonna put in there after. So we're all stuck. I mean, we're all stuck. Cambone owns a property that he rents out that had individuals chasing us down the street and spinning at us to the point where we had to go to the police station. Our concerns are valid. You can talk to Chief Jackson and you can ask why we're all here. This stuff is actually going on in our neighborhood from rental properties. We all own our homes, and we would all prefer that it stay single-family dwelling, not renting out different apartments. We have individuals renting out rooms next door to us. It's getting bad, and something needs to get done with it, and I'm sorry that unfortunately you have all of us here against you. Had things been different, it might have been a different outcome, but for right now, we really would prefer to stay single-family and in-law suite.
Okay, thank you. Yes, sir.
Mentioned that your work on the property may have increased the property value so far. You're not saying that anything that the variance would enable you to do would increase the property value anyway, right?
Okay, thank you. Appreciate all the participation this evening. It's important to us and will help us make our decision. So with that, we're going to pause and we're going to deliberate. We'll be back in a little bit. Thank you. Okay, we are back, and Travis, you have a motion to make for us?
I'd like to make a motion for hearing for case number Z-24-26 to deny the variance request as listed.
Okay, is there a second to the motion?
I'll second it.
All those in favor?
Aye.
Aye. Opposed? None. Unfortunately, the motion's been denied. So thank you, everyone, for this evening, and appreciate your participation. As we stated earlier, the next meeting will be November 26th at 7 PM. Do I have a motion to adjourn the meeting?
So moved.
Make a motion.
Second?
I second.
All those in favor?
Aye.
Aye.
Okay. Motion's adjourned. We'll see you in a couple months, or in a couple weeks. Yes, we're not going to hear any additional hearing, or any additional information on RHD. Nothing on the record. If you'd like to talk to us off the record, we'll be more than happy to hear about that. So thank you. Meeting's adjourned. We'll see you in November. Appreciate it.